My Lord, would you be the type who would hasten slowly in dealing with matters of certiorari, or you look at it case by case?
I will look at it on a case by case basis.
Very well. Let's make progress. Now, let me take you through constitutional mandate and judicial restraint. Our country's constitution grants broad interpretative authority to the judiciary under Article 2 and Article 130. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways?
Can you repeat the question again?
So, I'm saying that Article 2 and 130,
yes,
in your view, these provisions clothe you with those interpretative powers. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways? Now, I would give you one case.
Okay.
The Panilamte versus the Kojoga Adra versus Attorney General matter. My Lord Acting CJ wrote the judgment for the panel, and I will just explain to you. This had to do with public servant participating in our partisan political activities, and the contention of the plaintiff was to the effect that, yes, the 93-1, hold on a second. Because students are listening to us, I don't want to make a mistake. 91 to be, yes, it's here. 94, 3B, those prohibitions. Now, the contention of Mr. Agra in that matter, which had to do with the eligibility and the prohibition, who qualifies to be a member of parliament. So his case was anchored on 94 3B, which says that, let me read it in full. A person shall not be eligible to be a member of parliament if A, is prohibited from standing election by law in force in Ghana by reason of his holding or acting in office, the functions of which involve responsibility for or are connected with the conduct of an election, or responsibility for the compilation or revision of an electoral register. B, is a member of the police service, the prison service, the armed forces, judicial service, the legal service, the civil service, the audit service, parliamentary service, the statistical service, the fire service, customs, excise and preventive service, the immigration service, or the internal revenue service, or is a chief. Now, in this matter, Mr. Kojogadra's contention was to the effect that, yes, these have been listed, but there were officers in the public service, specifically Ghana Highway Authority and Ghana Education Service. And he does not understand why, if somebody is a member, a staff of Ministry of Education, the person is prohibited. Ministry of Health, the person is prohibited. Ministry of Roads and Highways, the person is prohibited. But if the person is a staff of Ghana Highway Authority, the person will say that I have not been listed. Now, my Lord Bafoboni took that conservative stand to say that to the extent that those others have not been listed here, it means that the Constitution did not contemplate them to be part. I disagree with him, but I yielded. I've not seen anybody going back to really further tease the mind of the Supreme Court on this. So it still remains a law, and subsequently, those who are in the public service mainstream but not listed here are part of our partisan political activities. So my question to you with this background is, to what extent would you say that the cautious approach in exercising this power has affected governance in one way or the other? Because obviously I see some practical challenges here where a minister is instructing an officer as Ghana Highway Authority or GES and knows that the person is the constituency or regional chairman of a party and is in opposition. I feel that the court was too reluctant in dealing with this matter. What is your view on that?
My view is very simple. Once the court has spoken, that is the law.
That is correct. I agree.
Yes. So I do not have any useful, addition to it.
My Lord, with respect, I'm not asking you to critique. What I'm saying is the basis or the gravamen of my question is the cautious approach. What is your view on this cautious approach to interpretation regarding governance? That's all. I only gave you that example to give a background because you said you didn't understand my question. You get my point now? Very well. Then
Honorable member, my Lord has answered the question that once the court has made pronouncement on the matter, he has no view on it. I think his answer is very clear.
I drew his attention to the fact that I wasn't asking him to critique the decision of the court in the Kojoga Adra case. I only introduced it to draw his attention to the mainstay of my question, because he had come back to say he didn't understand the import of my question. So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case, example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's the Minister of Finance at the time, I think Kwame Boproso, had prepared a budget which he was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there. And the then majority said that we are going along with it. And James Mensah said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament?
Yes.
Rawlings 193.
Yes.
And then 196.
Yeah.
So that was the second, my lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court held that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of recurrence violations of the Constitution, the provisions of the Constitution. So depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy courts. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if it demands that they must be pragmatic, they have to do it. So that is my answer to your question. Thank you.
Very well, my lord. My lord, you've spent the better part of your adult life after your call to the bar on the bench. I once remember you in your court saying that though you, the judges, don't go out, but perhaps you are the first to hear of every public rumor or gossip. I remember you telling us in your court. What it means is that you are equally aware of criticisms that emanate from the public space when you speak to shape governance and public opinion. Lord, would you agree with the position by some critics that the Supreme Court of our country has had the occasion to miss opportunities to provide judicial leadership in advancing constitutional justice and or protecting fundamental rights?
The Supreme Court has neglected this duty in shaping the... Is that what you said?
Oh, my lord.
Can you...
Very well.
Please?
Very well. So, you hear of criticisms. Definitely, even amongst you, yourselves, your judgment could go up and your brothers above you will say no. I am saying that the feeling that there are times that our courts have missed the opportunity to provide judicial leadership, which leadership would have helped in advancing constitutional justice or protecting fundamental human rights. Would you agree with me that we've had instances like that?
I disagree.
Okay. My Lord, much as I appreciate your answer, Is it your case also that in all situations, the Supreme Court has scored 100% in providing 100% judicial leadership?
I will not say that it's 100% because it's a human institution. Because the judges have the right to go right, they also have the right to err. That is why Article 129.3 even provides that when exigency comes or when there are situations that the Supreme Court will have to depart from its previous decision, they have the right to do so. They will not come out to say that they were mistaken anyway. But in doing so, they will require that there are exceptional circumstances for them to depart from their previous decisions. And then two, it must also be said that the exigencies of the time demand that they depart from their previous decisions. So I would say that being a human institution, they are prone also to make mistakes. They are human beings. I mean, and there's no judge under the sun whose decision has not one way or the other not be overturned. We are human beings. It's only God who is perfect.
Therefore, we've had instances of missed opportunities in judicial leadership. Now, my Lord, let me bring you back to this case you decided at the High Court. And if you can immediately recall, I'll refresh your memory on that.
Which one is that?
Yeah, I'm yet to say it. I'm yet to. In the matter of Ninoy Odonko versus the Iyoko, I can give you the brief fact of the case, just to recollect, for your recollection. If you remember, we would proceed. But if you...
It's a long time ago.
Sure, that's what I'm saying. I understand. My Lord, in the Ninoy Odonko case, Iyoko had frozen Ninoy's account without notice to him. The man had traveled out of the jurisdiction. At the time his account was frozen. He came back into Ghana after some 5 years and made an application before you. Iyoko at the time had already expended the money which was in their exhibit account. Your ruling was to the effect that the time for him to apply was far gone, so time back, procedurally, you could not apply for the defreezing at the time he was. However, the argument that he was not in the jurisdiction, and in fact, when the matter went on appeal to the Court of Appeal, your position was sustained. A certiorari was also filed, and relying on the Supreme Court's earlier decision, in a matter I will remember very shortly, he was again denied because applying for certiorari, per the rules of court, you need to do so in 90 days. So this gentleman lost every opportunity at all levels because of the time factor. He was not in the jurisdiction, his money is gone, and his fundamental human rights had been infringed upon. His right to have access to his own cash in his account had been taken away from him without trial. My Lord, my position is that the approach in interpretation was rather, unfortunately, very strict in this situation of Ninoy Odonko. and I consider it as a missed opportunity for the judiciary to have exercised a judicial leadership to protect fundamental rights, because on the fact it was all obvious the man has not been tried, he was not even on notice, but he's been affected by time because he could not apply. Equity would not be for his benefit in that instance. What, my Lord, in the present circumstance, would you advise the interpretation approach should be, with this in mind?
In the first place, let me say that I'm very happy that my decision was affirmed. And when you went to the Supreme Court too, you were overthrown. But coming back to your question, you see, judges, I mean, it's right that we do justice according to law. We don't do justice according to emotions. The court that you came to for it was not a what do you call it, human rights court. You were not espousing human rights issues. Okay, you were talking.
But the equity will look at substance, not form.
Oh, but the equity follows the law. Equity follows the law. So if the law says that within 1 year, and we started the Financial Crimes Court, I together with this judge who is no more with us. We started, and that time the Eco law had just been passed, so we were involved in it. And I quite remember that there is a provision in, if it has been changed, I do not know because I left the court a long time ago. Under that law, if your account has been frozen and the ECO people do not prosecute you within 1 year, you have the right to come to court to challenge it and have your account defrozen. You see, I'm not sure about whether your client has then traveled out of jurisdiction, and if it did, it wasn't served with notice. I'm not sure about that. But what I'm saying is that once the law provided the time frame within which to come to court, and you were outside the court, look, and it's 1 year. If you stay abroad for 5 years and you come to court, how will equity help you?
Okay, my Lord,
Honorable Leader, before you come in, let me suggest that if a question is posed to the nominee and the nominee is answering the question, we should allow him to finish answering the question before we pose another question.
my Lord, the case I wanted to cite to support the earlier point I was making was the NCS versus Intelstat case. Have you come across that case? It was a 3-2 decision.
NCA what?
NCS versus Intelstat. So it's the 2012 Supreme Court of Ghana Law Report. NCS versus Intelstat. Intelstat. NCS versus Intelstat.
Yes, what happened in that?
My Lord, it was a matter on appeal that went to the Supreme Court through a certiorari application. And the application was mounted after the 90-day window provided. And this was a case that my Lord Bedegbe of blessed memory departed from his good brother Atuguba. It was a 3-2. He went with my lady who is now with the Council of State, I forgot her name, Akoto Banfo, my lady Akoto Banfo. It was a 3-2. My Lord, in view of your argument that equity follows the law, and the fact that the courts in this instant, apply the limitation rule strictly. That yes, the person did not, was not in the country, but the fact that you were not in the country and the fact that the Yuku did not serve you notice will not endure to your benefit. The law says within 1 year apply. Now, if you read the Intelstat case very well, you realize that my Lord Atuguba was making an argument to the effect that the court would not sit idly by and watch statutory provisions being breached. Now, with this on mind, Iyoko has breached the law. The affected party did not apply on time. You think that for this, his fundamental human rights should still be denying him because he was, quote unquote, indolent at equity, and that the law says if you don't do it in a year, you are denied.
Let me repeat that I'm not too certain as whether the applicant in that case was served with a freezing order or not.
My Lord, for record, he was never served. I mean, I say so on authority, and I can furnish you with your own ruling. Later.
I just provided some guide as the chairman of the committee that when a question is asked, let's allow my Lord to answer the question, then we can interject. I believe that is the way we're supposed to go.
Okay, so maybe at a later stage, let me have the benefit of that judgment you are talking about. But my position is that you didn't go to Human Rights Court for enforcement of your human rights. Because if you went to Human Rights Court, the perimeters are different from the ordinary courts, like the Financial Crimes Court. They are quite different. And even the time limits, I think they are also different. So insofar as you didn't come within the rule, and equity will never come to your aid. Thank you.
It's okay. My Lord, let's deal with another issue that has to do with charting a judicial path for the future of our democracy. Because for me, I think we, the political activists, for many years, will rely on our courts to keep this democracy alive. And I say so with a lot of passion in me. Without you, the court, particularly the Supreme Court, this country's democracy will not survive. Now, with that in mind, what role do you think the Supreme Court should play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with choice between restraint and activism in cases of national importance?
To begin with, Chairman, are you listening to me?
Go ahead, the chairman is listening. My Lord, you may proceed. The chair allows you to go on.
You have distorted my thoughts. The question again, you ask the question, please.
My Lord, what I want to know from you, that what role should the Supreme Court play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with a choice between restraint and activism in cases of national importance?
To begin with, I have sworn judicial oaths, and throughout my practice on the bench, I've demonstrated my fidelity in the law. Whether it's about activism or posture and the rest of it. Indeed, it is the duty of a judge to come out with a decision that resolves dispute. A party who loses the case may not be satisfied or happy with it, but that will have been your decision anyway. So I'm not so obsessed with judicial activism and the rest of it. The core business of a judge is to do justice. And having applied the law to the facts of the case, you need to ask yourself, is it reasonable? Is it conscionable? Is it, all the qualifications that make a judgment or decision to stand the test of time? If, as a judge, you apply your judicial activism, or as we will call it, judicial philosophies and the rest of it, and at the end of it all, your law or the decision is not in consonance with the law, or I will say that then you have done nothing at all. It may be a bad law that you have espoused. So I will look at it from the pragmatic view that, look, I've sworn in judicial oath, and where it also comes to matters bordering the security of the state, we also need to be, that is why the Constitution itself says the principle is that it's capable of growth. It's an organism capable of growth. So you take all these things into account before we can come out with a decision that will meet the demands of the times. So that is what I would say that is what I would say in response to your question. Thank you.
My Lord, now I want us to deal with the issue of democratic inclusion versus constitutional restriction. And I want to pick your thoughts on this. How should the constitutional disqualification of dual nationals from holding certain public offices be balanced against Ghana's democratic values of inclusiveness and political participation?
My position is that this has been pronounced on by the court, the Supreme Court. So I do not think it will be better for me to, once the Supreme Court has come out with a position on this issue, that is the law. If there is the need for the law to be changed, maybe the appropriate time will come. But for now, that is the law, and I abide by it. Thank you.
But do you believe in the principle of inclusiveness in political participation in the light of the law prohibiting dual nationals?
Dual nationals, so far as I understand the law, if you have a dual, you a Ghanaian and you also hold nationality of other country, there are certain positions that you cannot hold. So if the Constitution says that is it. That is the law. And it's not about inclusiveness. The law is the law. Thank you.
Now, my Lord, without prejudice to existing case law principles and emphasis, without prejudice to existing case law principle, what in your view constitutes allegiance to Ghana in the modern global context? And how should this understanding shape the legal treatment of dual nationals seeking public office?
see, this allegiance, the issue of allegiance, it's borders on our security. So if you allegiance, at a particular point in time, it must be with one country. Because if you owe double allegiance, how do you have a situation where even those countries have an issue to deal with? So that is my answer. Thank you.
The honorable nominee, let me deal with the issue of diaspora contribution and governance. Let me pick your thoughts on it. In your view, in what ways can the law recognize the significant contributions of Ghanaians in the diaspora while maintaining constitutional safeguards for public service and national interest?
You mean Ghanaians in diaspora or?
Yeah, Ghanaians.
Ghanaians in diaspora?
Yes, that's correct.
Yes, they contribute significantly. But if they want to fully participate in our democracy, I think they should also take into account the fact that when elections are held, they must come here and also participate. I remember one case, I've forgotten the title of the case, where a Ghanaian in the diaspora came to Ghana to vote, and the EC was saying that the time for registering that candidate, that voter has passed, so it cannot be registered. He sent the case to the Supreme Court. And the Supreme Court looked at the merits of the case and directed that that voter must be registered. So, because they contribute, and I'm sure that we are all aware that when our president or we are trying to, woo them to come home and contribute their quota to the growth and development of the country, especially the professionals. So we need to encourage that. I have no problem with it at all. Thank you.